Your asylum case has been referred to immigration court. Well, you're about to walk into a process that operates on completely different rules than the one you just came from. You see, the affirmative asylum interview and immigration court are not two versions of the same thing. They're fundamentally different arenas, different structure, different roles, different stakes, different everything. And I'm going to break down exactly what changes when your case moves to immigration court so that you understand what you're actually walking into. And we're starting right now. I'm Brian Manning, and I used to be an asylum officer with the government. And in that capacity, I adjudicated thousands of immigration applications during the 11 years that I worked for the government's two main agencies for asylum and refugee matters. But now, as an asylum lawyer, well, my law firm helps immigrants all over the country to secure their future in America through asylum. Let me know in the comments if you have a case pending right now in immigration court, and tell me whether you're waiting for your master calendar hearing, that's the first hearing, or rather your merits hearing, sometimes referred to as your individual hearing. And look, if you haven't seen my video on what a referral notice from USCIS actually means and what your options are, please check that video out first. The link to it is down in the description. Okay, let's start with the most important structural difference between affirmative asylum cases with USCIS and the defensive posture in immigration court, because look, everything else flows from this. Okay, so the affirmative asylum process, that's the interview that you just went through with a USCIS asylum officer. That's what lawyers call a non-adversarial process. And that word or that phrase, non-adversarial, it matters. You see, non-adversarial means there's no opposing party. There's no government attorney sitting across from you preparing arguments against your case. The asylum officer's job is to evaluate your claim and determine whether you qualify for asylum. Now, they may push back, they may ask hard questions, they may be rude, they may seem skeptical, but they are not there to argue against you. You see, they're there to carefully assess your claim, acting as a neutral arbiter. Now, immigration court is a wholly different thing. You see, the immigration court process is adversarial, and that single word, adversarial, well, it changes everything. In immigration court, there's a government attorney on the other side. This is a prosecutor for U.S. Immigration and Customs Enforcement. Yes, ICE. And their entire job is to argue that you should be deported from the United States, okay? And this is not someone who's just evaluating your claim. Rather, they're actively building a case against you. They're going to review your application looking for weaknesses. They prepare cross-examination questions that are specifically designed to trip you up, to expose inconsistencies, to make you look unreliable in front of the judge. Yes, they want the judge to think that you are a liar. And sadly, in my experience, many of them are willing to play dirty in order to do so. These prosecutors can file legal motions meant to crush your case. They can submit evidence of their own, evidence that cuts against you. Okay, so this is the fight that you're walking into, and I want to be specific about what that means practically, because I think a lot of people underestimate it until they're actually standing in that courtroom. And when that happens, people get overwhelmed, okay? They can't explain their case clearly. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. Okay, let's go deeper on what specifically changes, because understanding each difference is how you prepare for what's coming. All right, the decision maker changes completely. So at the affirmative stage with USCIS, an asylum officer decided your case. That officer works for USCIS and they're a trained adjudicator, but they're not a judge and they're probably not a lawyer. In immigration court, your case is decided by an immigration judge. This is a federal official who presides over formal legal proceedings, and they are trained and licensed as a lawyer. Now, the immigration judge weighs arguments from both sides, your attorney and the ICE attorney. And they apply the law and they issue a ruling. This is a formal legal proceeding in every sense of the word. And critically, the judge is not bound by what the asylum officer concluded, okay? So your referral notice, it's not necessarily a negative mark that follows you the rest of your case. You see, the immigration judge evaluates your case fresh. Okay, what else? Well, the format of your testimony changes. At the affirmative asylum interview with USCIS, the asylum officer controlled the conversation entirely. They asked questions and you answered. But in immigration court, if you're represented by a lawyer, then your asylum attorney conducts what's called direct examination. It means they ask you questions, and they should be doing this in a way that's structured to allow you to present your story fully and clearly and convincingly. But you see, the prosecutor for ICE then gets to cross-examine you. They're going to ask pointed, probably aggressive questions specifically designed to find gaps and inconsistencies. Now, the pressure in the courtroom is categorically different from what you probably felt in the asylum office interview room. I've seen this from multiple angles. As a government immigration officer who interviewed thousands of applicants, and now as an asylum lawyer who prepares clients for exactly this kind of pressure in court. And I can tell you directly, court is much harder than the asylum office. It's more intense. It demands much more of you. And the asylum applicants who do best in immigration court, well, they're the ones who have spent real time preparing with their attorney, specifically for the cross-examination and getting to understand what that feels like and practicing it. The ones who have not done that kind of preparation, they're often visibly rattled when they get to court. And a rattled witness in front of an immigration judge is exactly what the ICE attorney is trying to create. Okay, next up, evidence is treated with much more formality in court than at the asylum office. So in the affirmative asylum process with USCIS, you might have submitted a personal statement, maybe some country conditions information, and whatever evidence you have. And generally speaking, everything surrounding the evidence was probably pretty lax. But in immigration court, evidence is presented more formally. Your attorney introduces exhibits, and the ICE attorney can object to them. Now, the judge rules on what comes into the record. Things like witness letters, country conditions reports, maybe you have photographs or medical records for evidence. All of this gets scrutinized at a deeper level. The ICE attorney can look for reasons to challenge every piece of documentation that you put forward. Now, judges usually will not allow evidence that is submitted late or that doesn't meet certain standards. And then there's the issue of the legal brief. In the affirmative process with USCIS, your attorney might have submitted a legal brief, but many applicants unfortunately go through it without one. Most lawyers don't do it. We always do. Now, in immigration court, I believe a solid legal brief is required for serious representation. Your asylum attorney should write a brief that lays out the applicable law, applies it to your specific facts, and argues precisely why you qualify for asylum under United States law. The ICE attorney can file their own brief arguing the opposite. Now, your legal brief is your legal voice in the record, and it frames how the judge thinks about your case before you ever walk into that courtroom. If it's done well, it can be a powerful part of your case. So let me pull all this together for you. When your case moves from the affirmative asylum process with USCIS over to immigration court, several things change simultaneously. The decision maker goes from an asylum officer to an immigration judge. The process goes from non-adversarial to fully adversarial, with a government prosecutor on the other side. Your testimony goes from question and answer interview to sworn testimony with cross-examination. And the evidentiary and legal standards become significantly more demanding, and you really need a great legal brief. And as you can imagine, it takes time and effort to address all of these challenges. And that's exactly why people who went through the affirmative stage alone, without representation from an attorney, and are now facing immigration court, well, they need to think very seriously about getting an asylum attorney for this stage and doing so now. If you received a referral notice and you want to understand what defending your defensive asylum case in immigration court actually looks like, please call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us right now to schedule an asylum strategy session so that we can help you to secure your future in America through asylum. Again, I'm Brian Manning, asylum lawyer and former government asylum officer, and it's truly an honor to serve you in your asylum journey.